Greetings, this is Management 430, Human Resource Management, and this set of lectures is going to be on how we determine and manage benefits in an organization. Benefits are a part of the total compensation that an employee gets. It's on the pecuniary or the financial side of things because organizations have to pay money to provide benefits to their employees, a wide range of required and voluntary benefits. So we will go through the different kinds of benefits out there, what you need to be aware of, and then how we manage those systems. Benefits are broken down into two categories. There are some that are legally required benefits and some that are entirely voluntary, that the organization can choose whether or not they want to offer them. Healthcare kind of fits in a weird middle because, as you saw from our compensation law, the Affordable Care Act basically says if you don't offer benefits, you're going to have to pay a penalty anyway into the system. So it's technically voluntary, but there's a financial penalty if you don't. So you can call it voluntary, you can call it mandatory, or something in between. But nothing is left to the imagination when it comes to the kinds of benefits that you can give people. I worked for an organization when I lived in New York City that provided transportation benefits. Like they would give me a certain amount of money for me to have tokens for the subway, so I could have easy access to the subway. So there's a whole host of different options available for people, and it only is limited by your imagination about the kinds of things that you can provide for people. Let's start with the one we are probably most familiar with, which is Social Security. The acronym OASDHI stands for Old Age, Survivors, Disability, and Health Insurance. And the health insurance that they provide is Medicare for the elderly, and there's prescription benefits and all sorts of things attached to that. But that's what Medicare is. It's part of the healthcare system for Social Security. So when you have your Social Security taken out of your check, you pay some and then the employer pays a portion. That all goes into the fund for the government, and you then, when you get to a certain age, are allowed to take your retirement benefits, which is the old age benefits. If you die and you still have minor children, your minor children would be able to receive Social Security supplements until they are 18 years of age. If you're disabled and you can no longer work, there is Social Security disability, and it provides modest cash flow for an individual so that they can pay some basic living expenses. It doesn't cover everything, but if you are completely incapacitated and unable to work, disability will support you in that manner. And then, as I said, Medicare is the last one. And it's all funded through the Federal Insurance Contributions Act. And again, as I said, part of it comes from the employer, part of it comes from the employee, and there are specific percentages. It's almost 50-50, but not quite. Like I think the employee pays like maybe 1% more. But it's roughly a 50-50 split. So just reiterating and going into a little bit more detail, the retirement income, the survivor benefits, and that's basically for anyone who's a survivor, and even a spouse can get survivor benefits, and particularly if you're caring for young children. And this is a really important fact. Until probably the early 70s, men were not eligible for survivor benefits. The expectation when Social Security was set up would be that the breadwinner, quote unquote, the man or the husband in the relationship, was the primary breadwinner, and if they died prematurely, the surviving widow would be able to get survivor benefits to supplement the fact that they are missing their spouse's income. And Ruth Bader Ginsburg, who was a Supreme Court justice, if you are not aware, she argued the case in front of the Supreme Court to argue that men should have the right to get survivor benefits as well. Groundbreaking, and it reinforces that employment law covers everybody. Even though we might say, well, women and minorities are more likely to have issues, and that may be true, but the employment laws cover everyone. Male, female, majority ethnic groups, minority ethnic groups, doesn't matter. Everybody is protected, because if someone is making a decision to discriminate against you because of your sex, because you're either male or female or non-binary or transgender, if you are making a decision based on someone's ethnic group, that is considered illegal, period, whether or not they're making it because they're white or making it because they're black or Latino or anything else. The disability income, as we talked about, it's anybody who faces a disability that inhibits their ability to work, that they can receive disability income. And then Medicare is the government-funded health care for people 65 and older. Workers' comp is the next one you should be aware of, and this is really important from the perspective of accidents at work and workplace safety. We'll talk a little bit about workplace safety also in this module, but I want to go into a little bit more detail on the workers' comp here. The company pays a percentage of their payroll in the form of a tax, and that goes to the state workers' comp fund. Then the workers' comp fund is available if an employee is hurt while doing the work of the business, right? So let's say you require me to drive to a client site and to take care of some business at the client site. And while I'm on my way there, I get into an accident. Now, you might say, well, people drive to work all the time. But this is not about driving to work and driving home from work. This is about me being at my job and my boss telling me, you need to go to this client site and deal with this client as part of your job. So because it was required for the purpose of their job, that is considered job related and hence would be protected because you would need to be that would need to be addressed. Now, it provides a modest income replacement, not a lot. So if you're a high paid employee, you are not going to get workers' comp funds that will replace your full income, but it gives you something. It enables you to still be able to pay some smaller bills and things of that nature. It also will cover your medical costs, and you may or may not get a settlement based on the accident and all the issues and the pain and suffering that goes along with it. So sometimes you have an accident, the medical bills get paid, the surgeries get paid, whatever the physical therapy gets paid. You get paid that modest income while you are on workers' comp, and then you may get a settlement if there is a temporary disability or a permanent disability, and that's kind of like a pain and suffering thing. And this is no fault. Let me be clear. This is not like, oh, the employee tripped and fell off of their own 2 feet, and therefore they don't have to pay, the company doesn't have to pay workers' comp, and that's not the case at all. It's a no-fault clause. It doesn't matter whether or not the person tripped and fell and did it to themselves or not. If they are hurt while they are on the job, they are supposed to be protected by workers' comp. The only kind of exception to this is if you already had a pre-existing condition such that you were already undergoing physical therapy for your back, and then you fell at work and you were asking for a settlement to deal with the care for your back. Well, the problem is you were already getting your back care managed under a different plan, and so the organization might argue that back injury is not because of the trip and fall, that back injury already existed because you were already undergoing treatment for it. So it's important to know that a company may push back and may choose not to pay for your benefits. I had a friend recently go through something like this where she slipped and fell working for a pretty big employer here in the Metro East, and they said to her, well, you had some back issues a couple of years ago and you went to the doctor, and so obviously you had a pre-existing condition, and they had to demonstrate that there was no pre-existing condition, which was absolutely true. Whatever had hurt her before wasn't a big issue. She had went and got whatever care she needed for it, and was able to work and had no restraints on her. So there was no pre-existing condition, although the company tried to argue for that. So ultimately, it was settled in court. She won her case. She won several appeals, and still won her case. And then they eventually settled with her, and went through the motions of making sure she got paid, and took care of everything that she needed to have taken care of. If your employee dies on the job, then obviously there are also benefits that will go to the family because the individual passed away. So that's like a survivor benefit as well. But it's different than Social Security. It's paid within the payroll taxes of workers' comp, and it is then given to that central fund. And then payouts come from that central fund. It's a form of insurance, basically. Unemployment insurance is insurance that the company pays for, again, also at the state level, that is designed to provide supplemental income for somebody who is laid off or fired from a company. So unless you have gross negligence, which is why you were fired, if you were let go because you were just a poor performer, that's a very different thing than I stole from the company and now I also want to get unemployment insurance. And that doesn't work that way. So I had a situation with an employee that worked for me who was supposed to take care of something, didn't take care of it, went out of town for several days without permission, didn't call in, didn't write, came back as if nothing had changed, and she came back to work, and she was laid off and told, she was fired and told that she would not come back. When she applied for unemployment insurance, we demonstrated the damage that she did to the company business and the way that, what she handled and how she neglected her job duties, didn't call in, didn't do anything that showed gross negligence, and they were able to win their fight to not pay her unemployment rates. So she did not get unemployment working for the company because of that scenario. But generally speaking, if someone gets laid off, no fault of their own. If someone is, generally a good person, follows all the rules, but they just weren't performing well, they're eligible for unemployment insurance. And most companies will do a good job to make sure that people get the unemployment that they need, unless there's, an extreme circumstance, as I said. The unemployment agency helps with job search also. They also monitor where you apply to make sure that you're actively looking for jobs. You can't just sit back and go, oh, I'm just going to collect unemployment insurance and not look for work. Now, there were things that were a little bit different during the pandemic because we were just in a really weird place. So our unemployment insurance didn't work the normal way. There were some exceptions made, exceptions to the rules that were made, not a big deal. But ultimately, you are eligible for unemployment insurance if you demonstrate that you're looking for work, and temping or going out and applying for jobs, and then you log in where you applied and what you did to try to find a work. And all of this again is funded out of payroll taxes that goes through the employer and is contributed by the employer to pay for unemployment insurance. So there's a certain percentage that you pay based on what your total payroll is. I believe we already covered the Family and Medical Leave Act, but just as a brief reminder, Family and Medical Leave protects job security for when an individual needs to take unpaid leave due to family-related issues like birth of a child and major illness. It also could be for foster children and adoption and things of that nature, as well as medical issues for you or medical issues for a family member where you are the primary caregiver in that circumstance. The Act covers all employers, public or private, that have 50 or more employees within a geographic region. It's usually like 70-something miles, I think 75. And so if you are outside of 75 miles from the headquarters of your organization, and uh, then that would not be counted in that pool of 50 employees. If you're working remotely, doesn't matter. If you're working remotely, you are still considered to be working on that site. That would only count there. And you have to have it worked for at least 12 months for your employer before you would be eligible to get the FMLA.